Okay, everybody, we're going to get started. Welcome. I like to take polls. I'm the poll person, so I am curious, how many of you are 1Ls? Good crowd. 2Ls? Do we have any 3Ls? Thank you for caring. LLMs. MLS students. Guests. All right, welcome. As you know, the Supreme Court heard oral arguments just last week in the Andy Warhol Foundation versus Goldsmith case. And today, we get the great opportunity of sitting down with leading experts, all at UCLA, to discuss the evolving doctrine of fair use, examine appropriation art, and explore how the Supreme Court's decision in the Warhol case will shape copyright law and impact the entertainment and media industries. Welcome. The Zifrin Institute is excited to host this special and timely program featuring UCLA professors and IP experts from left to right, David Nimmer, Mark McKenna, Zian Tang, moderated by Dale Cohen. This program is especially exciting to me because art law was my favorite class in law school. And so with that, please let me introduce our panelists and moderator. David Nimmer. Professor David Nimmer is of counsel to Irela Manella in LA. He's both a professor from practice at UCLA School of Law and distinguished scholar at the Berkeley Center for Law and Technology. Since 1985, Professor Nimmer has authored and updated, we've all read it, Nimmer on Copyright, the standard reference and treatise in the field, first published in 1963 by his late father, Professor Melville B. Nimmer. Professor Nimmer is widely recognized as a foremost expert in copyright law. Professor Nimmer also represents clients in the entertainment, publishing, and high technology fields, and he's twice served as co-counsel representing clients before the US Supreme Court. Next in line, Mark McKenna. Professor Mark McKenna teaches and writes in the areas of intellectual property and privacy law. Though his core area of expertise is trademark law, he has written broadly on nearly every area of IP, including utility patent, design patent, copyright, and the right of publicity. His most recent work has focused on the intersection of intellectual property rights regimes and the intersection of IP rights with adjacent rights. Mark is the faculty director for ITLP, that's the Institute for Law, Technology, and Policy, and he currently teaches torts, trademark law, design law, and perspectives course on the law of geographical indications. Zian Tang. Professor Zian Tang teaches and writes in the area of IP. She is currently researching and writing on the roles that technological evolution and new modes of dissemination play in the law of intellectual property. Professor Tang previously served as lead counsel for Facebook and as an associate at international law firms Mayer Brown and Skadden Arps, where she worked on a variety of transactional and litigation matters in the technology, media, and entertainment sectors. She is currently teaching entertainment law, intellectual property, and a perspectives course on the law, norms, and theory of copying in contemporary art. Finally, Professor Dale Cohen, director of UCLA's amazing, that's a pitch, guys, amazing documentary film legal clinic, which provides pro bono legal services to documentary filmmakers. His research interests include media, entertainment, and communications law. Professor Cohen also serves as special counsel to Frontline, the award-winning PBS documentary series, where he counsels and leads the news team and producers on legal issues and ethical standards. His extensive experience also includes positions at Radio Free Europe, Radio Liberty, NPR, Cox Enterprises, Tribune Company. Professor Cohen was also a litigation partner at the law firm of, I don't know how to pronounce this, Sonnenschein, Nath, and Rosenthal, now Dentons in Chicago. In addition to leading our documentary film clinic, Professor Cohen also teaches news media law in the digital age. So I hope all of the students of Professor Nimmer, McKenna, Zian Tang, and Dale Cohen are here today. And with that, I hand the mic over, the food's good, to Dale.
That was excellent. Is this on?
Take it over, yeah.
Okay. All right, so we're here to talk about the Andy Warhol Foundation versus Goldsmith case. And just since we're in the poll mode, how many of you are familiar with the case? Good, excellent. Okay, so I'll go through the facts really quickly. Lynn Goldsmith is a well-known portrait photographer, particularly in the rock and roll sphere. She's done hundreds of album covers, lots and lots of work that probably everyone has seen in some magazine, newspaper, or website over the years. In 1981, that's how long sometimes these things brew, Newsweek commissioned her to do photos of Prince. They were never used ultimately by Newsweek. A couple of years later, Vanity Fair was doing a piece about Prince. This was relatively early in his career, and they commissioned Andy Warhol to create a Prince image for an article about him. They paid Lynn Goldsmith $400 for the photograph, or a series, I think it's this photograph in particular, yes, $400 to use this photograph as a reference for Warhol's work, and then attached one of these Warhols that you see on the right-hand side, backwards, my left, to an article in Vanity Fair magazine. Goldsmith apparently was unaware of this, or at least so she's claimed in the litigation. Years later, now we flash forward to 2016, Condé Nast, which is the parent company for Vanity Fair, decided after Prince died to do a commemorative magazine. And they decided that they were going to use one of these Warhols as the cover of the magazine. Unlike in Vanity Fair, where they gave credit to Goldsmith and paid her a license fee, they neither gave her credit nor a license fee in connection with the cover of this commemorative magazine in 2016. Goldsmith discovered then that Warhol had done this work, that he had done a whole series of 16 of these works based on her photograph, and sent a letter to the Andy Warhol Foundation, which is the successor to Warhol after he passed. The Warhol Foundation filed, after they tried to negotiate and couldn't reach an agreement, the Warhol Foundation filed a declaratory judgment action, claiming that they had a valid copyright and that they were not infringing upon her copyright. So they took the aggressive step of filing the lawsuit. In the district court judge, Judge Kodal, a well-known district court judge, after discovery was completed, after all the depositions and so forth, granted summary judgment to the Andy Warhol Foundation. He found that, in fact, it was fair use, applying Section 107. Why don't you bring that up for us? Which is the fair use provision of the Copyright Act. Best known as the four-factor test, and David will talk a little bit more about this. In particular, the district court found that Warhol's work was transformative, and that's the issue that's really before the Supreme Court right now. He found that there were many aesthetic changes, that the work was recognizably Warhol's, and therefore it was not going to have a market impact upon Lynn Goldsmith's licensing or derivative market, and that because the work was so transformative, all four of the factors were going to favor the Warhol Foundation and granted them judgment that they had not infringed, that they owned the copyright to these works. The case was appealed by Goldsmith up to the Second Circuit, which came to exactly the opposite conclusion. On all four factors, the Second Circuit found in favor of Lynn Goldsmith. They found that even though the district court had found that there was a new purpose intended by Warhol in his work, in particular what the district court had said was Goldsmith's work showed what a vulnerable and insecure character Prince appeared to be, whereas Warhol's work showed him as an iconic, larger-than-life character, much like Warhol's other work, which commented on commercialism and pop culture in the United States. The Second Circuit said that the subjective purpose of the photographer and the artist wasn't really the issue. They engaged in a side-by-side comparison and said basically the work was recognizably based upon Goldsmith's photograph, and therefore it was not sufficiently transformative. And from that, all of the other factors flowed in favor of Goldsmith, so they reversed the summary judgment and found that it was not a fair use as a matter of law. And in particular, they looked at the question of whether or not the purpose and function of the work was transformative or used differently, and said they're basically the same thing. They're both works of art, they're both portraits of Prince, and therefore Goldsmith was entitled to judgment. A cert petition was filed, and much to the surprise of most practitioners and probably most of the people on this panel, the Supreme Court took the case. As you guys know, they don't take very many cases, a very small fraction of cases, but they decided to take this one, which was a big surprise because they had just decided a fair use case 2 terms ago. And there have only been a handful of them. And with that, I'd like to turn you over to David and ask both to describe the fair use cases from the Supreme Court and how you think this case got here.
Good. Okay, thank you. There have been a number of fair use cases that the Supreme Court has decided. It's an unusual field in as much as most domains of copyright law are completely unaddressed by the U.S. Supreme Court, or perhaps on one occasion. If you take my treatise, there are roughly 400 sections. Most of them do not have any Supreme Court decision on points, such as community property and copyright law. Sometimes an issue such as latches will have one Supreme Court case on point. But fair use is the area that is most discussed by the Supreme Court, so one would think it should be the clearest. It was the first issue that was confronted in the case that you see up there. Oops. We're starting off in 1984 with the Sony Betamax case. And I want to run through each of those cases briefly to give us the prologue to our current case. So the factual record for the Sony Betamax case was developed in 1976. A revolutionary technology came out that allowed people to timeshare. If Gunsmoke was on Sunday at 9 o'clock, that's the only time that anyone could see it, until the invention of this machine that allowed you to tape it and then watch it Tuesday at 3 p.m. The Supreme Court ran through the various factors. I should mention that the district court held in favor of fair use, the Ninth Circuit reversed, and then the Supreme Court reversed that determination. Looking at the purpose of the use, well, the plaintiff's purpose was to have a movie or TV show. The defendant's purpose was to show it, the same thing. So that seems to be unfair. What's the nature of the copyrighted work? Well, here we are in Los Angeles, where we are forced to acknowledge that the highest and greatest art form of all time ever is the Hollywood motion picture. So that is what was at issue here. Very unfair to copy it, looked at from the second factor. Third factor, how much was copied? The more that's copied, the less fair it is. 100% was copied. So the 3 first factors all tell you that it's unfair. And yet the Supreme Court decided that it was fair, primarily based on the 4th factor. Because after all, people had been invited to watch Gunsmoke, and so what did it matter if they simply watched it later? And there was a dissent in that case. Okay, then we get to the next case. The very next year, after having held in favor of fair use, another case comes to the Supreme Court in which it ruled against fair use. The Southern District of New York held no fair use. The Second Circuit reversed, and the Supreme Court reversed that, again with a dissent. So you're beginning to see a pattern here. And you can also see a pattern of how indeterminate these factors are that are supposed to give clarity. What was the purpose of the use? Well, if you look up in the preamble, one of the presumptively fair uses is news reporting. In this particular case, Gerald Ford came up with his autobiography, A Time to Heal, in which he spoke about his pardon of former President Nixon, one of the most newsworthy events of all time in American history. So the purpose of The Nation magazine running a scoop with 300 words was for a very protected purpose. Now, what was the nature of the copyrighted work? Unlike a massively creative Hollywood blockbuster motion picture, what was at issue here were the memoirs of a president, not expressed with great literary flair, primarily containing a recitation of the facts while he was in office. So those 2 factors would seem to massively favor fair use. And how much was copied, the amount of substantiality? Here, unlike 100% being copied, it was 300 words out of 200,000, so a tiny, minuscule fraction. So the first 3 factors, again, powerfully militate in favor of fair use. But once again, confounding expectations, the Supreme Court ruled to the contrary, that it was unfair. Why? Because Time magazine had agreed to pay $12,500 for its first serialization rights, and that market was obliterated by the scoop, and for that reason, there was an adverse effect on the potential market. Once again, successive reversals leading to somewhat indeterminate status of the law. Now we go forward to the next decade, and we see that the Supreme Court again took a copyright case, this one involving a popular musical composition.
This is the one.
No. We're going to start with Roy Orbison. This was a popular song that you've probably all heard, and it was a copyrighted composition. Along comes somebody and says, may we make a copy of your composition? The answer is no. And here's the original work. You have to make it louder, I guess.
Want to dance?
Pretty woman, walking down the street, pretty woman, the kind I like.
Good. So after being denied permission, here is what Two Live Crew put out.
Apologies for the lyrics here.
Walking down the street, pretty woman, girl, you look so sweet.
Well, okay. So, and what we did not hear is, you know, that hair at legit, it looks like Cousin It. You got to shave that. I know it's pretty rough. You got to shave that stuff, etc.
Hear more?
Okay. Okay. Well, I think you've heard enough to understand. The
Highly recommended.
the district court in Tennessee ruled that was fair use, but the Sixth Circuit was not impressed and reversed. And then we had another successive reversal by the U.S. Supreme Court to hold that it is fair use. Dale has already introduced to us the concept of transformative use, which is what this case adopted in very large measure. It was a helpful step forward at the time. It helped to resolve this case. The Supreme Court said you still look at all four factors, but a very important one for the first and the fourth is how transformative is the work? Does it have new message, new meaning? Does it serve a different purpose from the original? And based on all of those factors and the fact that one has to evoke a large amount of the original work in order to make the parodic point, the Supreme Court basically held in favor of fair use in that case. That, I thought, was an excellent decision at the time, and for about a dozen years, it served us in good stead. Then in 2006, by my lights, things began to unravel. Courts began to apply transformativeness to the exclusion of anything else, and interestingly, it arose in the realm of visual art and appropriative art, such as along the lines of the current Warhol case. Jeff Koons was vindicated in copying a popular ad for an exhibit he was putting on. In 2013, the appropriation artist Richard Prince was held justified under fair use to massively copy an artist's photographic collection of Rastafarians that he had made in Jamaica. And so transformativeness threatened to eat up the entire field, including one study that said when a work is held to be transformative in 95% of the time, that means it's going to be held fair. So transformativeness was going out of control at that point. By the way, when I mentioned the word Prince, it could refer to Prince, the artist, who's at issue in this case, or the photographic prints that Andy Warhol made, or the appropriation artist Richard Prince. So try to keep all of those straight. We now get to just last year, after a very, very long hiatus of 27 years, the Supreme Court returned to the domain in the case of Google versus Oracle. This is a highly technical case. It has to do with APIs, applications, programs, interface. Oracle owned the Sun Java library. Google wanted to make interoperability with its new Android system, and it copied 39,000 lines of code. Now, for technical reasons having to do with copyright law, I personally thought that that was legitimate for Google to do, but not based on fair use, based on the lack of copyright protection for certain forms of computer software. So I participated in an amicus brief on behalf of Google. Now, Google did prevail in this case, but not on that grounds of copyrightability. Instead, the Supreme Court took the occasion to once again revisit fair use and to talk about, to hold Google's usage fair use. And once again, we see the same paradigm. A district court held it's fair. In fact, in this case, it was a jury verdict that held it to be fair, the only one among all the cases. The Federal Circuit reversed, and the Supreme Court, in turn, reversed that ruling with multiple justices in dissent. So I'm going to end here, but if we just look at the statistics from the past, every single case has involved multiple levels of reversal. So on that basis alone, we would expect the Second Circuit to be reversed. On the other hand, it was only once that there were two succeeding fair use cases back to back, and in that case, the first one was fair, and the second one was held unfair. So on that basis, we would expect an affirmance. But obviously, the statistics are not enough to draw any lesson for this case. This case will be decided upon its own facts, and for those, I turn to my colleagues.
So I want to get to the Warhol argument and Zian in a moment, but Mark, it's clear there's a lot of confusion in this area. Is there any way to actually reconcile these cases that David has just told us about?
Test first.
Oh, yeah.
Oh, no, you can.
Oh, okay.
Turning off Siri.
So I guess the first thing to say is that, one thing that's always hard to do is if you just look at the sort of tip of the iceberg and you look at the cases the Supreme Court gets, and then you try to draw conclusions from that about the clarity of an area of law, right? And so remember, first of all, the cases the Supreme Court takes, by and large, are the hardest cases. That's why they go to the Supreme Court. There's actually really good scholarship done by Pam Samuelson and others that suggest there actually really are identifiable patterns in fair use cases. In order to find those patterns, you have to do more than just read the Supreme Court cases. You have to read, all the cases that David puts in his treatise. And so, but of course, once you get to the Supreme Court level, they can do whatever they want. And so that's, I think, the challenge with these cases. And so one of the things that has always stood out to me about the case is that the government's brief in this case tries to make an argument that you should evaluate fair use only on the nature of the use, not on the basis of what the work is, which is to say, the distinction they're trying to draw is that you don't decide that something is fair use for the work, full stop, meaning that for any and all purposes, that work is now fair, no matter what you do with it. It is instead sort of like a contextual judgment based on the nature of the use. And the reason that matters to them is what they're trying to say is, the first use, the one that was licensed, that might have been legitimate, but then the sort of additional uses after that are not legitimate, even though they might have derived from the same original act. And so one thing that I think of, if you think about these four cases, is they just don't map onto a single description in that way, right? So if you take Sony is a use case, right? It's like full recording of an entire movie for something other than private viewing, and time shifting is clearly not going to be fair use, right? If I fully record the movie and I broadcast it in the room, no way that's going to be fair use, right? There's something essential about the fact that it was for private copying, right? The nature of the use that made it fair. But then you take Campbell, and it's like, no, that's a work case, right? It's the fact that it's a parody that makes it a fair use, and then it doesn't really matter how you use the song after that. Once we've declared the work to be a fair use, then the judgment that it's a fair use travels with the work, right? It sort of sticks to it that way. And the government was trying to make an argument that there was some essential characteristic of fair use that made one or the other of those right. And I guess if I look at the four of them, I see a very mixed picture in that respect.
All right, so Cindy very much wanted Cindy wanted us to take a poll now and then see if you've changed your mind
It's
later.
interactive. It's a QR code. We love it.
Okay, all right, so there it is. Why don't you guys vote on which side
I thought they were all taking my picture.
should win?
Zach Dye is going to tabulate the results and then at some point tell us what we think at the beginning of this talk and then at the end.
Okay, so,
As we go on, yeah.
all right, so Zian, why don't you tell us about the argument and the three pretty distinct viewpoints that were presented there?
Okay, I'm gonna click through it. I'm clicking through it. Okay.
You'll click through and I'll press the audio.
Press the audio. Okay, so should we listen to? Okay, so there were three parties that argued before the Supreme Court. The first was Latham and Watkins on behalf of the Warhol Foundation, and so why don't we listen to a snippet from their opening argument, which I thought was quite concise and to the point.
Both courts below agree, and Goldsmith doesn't dispute, that Warhol's print series can reasonably be perceived to convey a fundamentally different meaning or message from Goldsmith's photograph. The question in this case is whether that different meaning or message should play a role, any role, in the fair use analysis. Our answer is yes. Warhol's transformative meaning puts points on the board under factor one of the four-factor balancing test. Goldsmith and the Second Circuit say no. Warhol's new meaning is categorically irrelevant and can't be considered as part of factor one or any other factor.
Okay, so I think one of the interesting things about the case is the way that it was framed to the Supreme Court in the cert petition. And that was done by Latham on behalf of the Warhol Foundation. And they framed it as a very narrow issue as to whether or not the Second Circuit erred in their factor one analysis on transformative use when they wrote in their opinion that because, as Professor Cohen noted earlier, because Warhol's work recognizably uses Goldsmith as the source material, that it cannot be transformative. And I think that's a pretty significant deviation from what the Supreme Court has pretty clearly held in Campbell. And significantly, Campbell was quoting from an earlier law review article by Judge Pierre Laval, now in the Second Circuit, which that law review article helped propel transformative use and put it on the map as one of the most important considerations in fair use, perhaps to the detriment of other factors, as Professor Nimmer might argue. But nonetheless, that article and Campbell's subsequent quotation of it argued that if a secondary work contains a new meaning, new messages, and is for a different purpose, that would be considered transformative. It seemed like during oral argument that the justices pretty much agreed that the Warhol work contained a different meaning and a new message. It was, in other words, a productive use of Goldsmith's source material. So there's been this dichotomy in the scholarship, or if you look at, that's derived from the case law, or if you look at two types of infringing works or secondary works, one is what's known as a productive use, where you take the original material and do something else with it by making a new creative work, right? So if we look at the purpose of the Copyright Act, which is to encourage creative production, productive uses are generally encouraged by fair use because you're creating new creative works and adding to the pantheon of cultural progress. Other uses, such as reproductive uses, might be functionally different, such as in the Betamax VHS tape case, right? Or in the Google Books search case, right? Where you digitize books, you digitize photographs and make them into thumbnails. Those are reproductive uses. They may or may not be fair. The case law is mixed on that. But this doesn't really fit into that. So here's, by the way, another great quotation that brings in two, not one, but two UCLA law professors, Professor Nimmer, who's sitting here next to me, as well as Professor Neil Netnall, who teaches copyright in this law school.
Campbell unambiguously requires an examination of meaning or message. Campbell unambiguously requires an examination of meaning or message. Google reaffirms that test and cites Warhol's soup cans as a paradigmatic example of when it's satisfied. Goldsmith's test is at odds with both cases.
So by the way, Campbell here can mean either Luther Campbell or a soup.
Yes.
Prince, Campbell.
Just say Prince and Campbell.
So much like doubling. Okay, so I think one of the very interesting things about this case is that when you look back at court opinions that talk about artistic creation, Warhol comes up often as sort of the godfather, right? The automatic example that courts like to throw out to say, well, if a picture of soup cans can be transformative and is obviously protected creative expression, why can't, whatever the defendant happens to be making in that particular case? So this is a great example of that. Mr. Martinez, on behalf of the Warhol Foundation, cites to, this is like 3 levels deep, by the way, cites to the Supreme Court's decision in Google versus Oracle, which had made a notation about Andy Warhol's Campbell soup can pictures. And then in that opinion is a citation to Professor Nimmer's treatise, and Professor Nimmer's treatise was citing to a law review article by Professor Neil Netnall. So, okay, so 3 levels deep, 2 of them UCLA.
And if I could just interject, the California Supreme Court has also cited to Warhol as being a transformative use in the context of right of publicity in a case called Satirup, the Comedy 3 Productions case. So there's lots of judicial recognition that a Warhol is really something different.
Okay, so yeah, so that's a great, thank you very much for that, because that's actually helpful for what I want to say next. So, Campbell was a parody case, all right? The Roy Orbison Pretty Woman, that was a parody case, all right? There's a difference between parody and other types of protected fair uses. So what Two Live Crew was doing in their appropriation of Roy Orbison's song was to make fun of Roy Orbison, or at least that's the argument that they made before the Supreme Court and in the lower courts, which won and carried the day. The Supreme Court in Campbell never said that parody was the only type of productive use that constituted fair use. Nonetheless, okay, parody has become kind of the paradigmatic example of fair use, such that the dicta in Campbell that says, parody has to poke fun at the original. It has to take the original as the object of its ridicule, thereby commenting on it, thereby somehow criticizing it. That has been subsequently taken as sort of the only type of protected productive use in other doctrines that borrow substantially from copyright law, such as right of publicity, which Professor Cohen just mentioned. And so in right of publicity cases or in trademark First Amendment fair use cases, courts have often held that in order to legally appropriate someone else's mark or someone else's image, you have to be commenting on it, criticizing it, or otherwise directly targeting the thing that you are taking and appropriating. And so this is the argument that was taken up and appropriated, really, by Lisa Blatt, who was representing Goldsmith in this case.
Factor 1 focuses on purpose. What is the reason or justification to take another's copyrighted work? The reason can't be to avoid paying the customary price or the drudgery of coming up with something fresh. The copier has to explain why it needed and not just wanted to use someone else's expression.
Justice Kagan pushed back at that when she was arguing.
Yes, exactly. So up here on this slide, you'll see Justice Kagan, who I think was probably the most active, engaged member of the court in these oral arguments and seemed to have a really firm grasp on the issues, pushed back on Ms. Blatt and said, but Campbell didn't say that this was the only protected fair use.
Where do you get the idea that you have to need the original work?
So where we get the need is from the 5 times in Campbell that the court said it, but it's...
So Campbell doesn't say that. Campbell says, well, if you need the original work, that's the paradigmatic case. But it doesn't say that if you don't need the original work, it can't be transformative.
So yeah, let me just state our test. When the defendant has an asserted purpose for copying someone else's work, you ask, was the copying of the original needed to best achieve the copier's purpose?
So I don't know whether the United States, in arguing their case, was reacting to Justice Kagan or not, but they took a somewhat different position.
Yeah. So do we? Actually, before we get to the clip of the government test, I guess I'll say I think it's helpful that this case is maybe clarifying a lot of the confusion that stemmed from Campbell that subsequently trickled through to lower court opinions on either copyright fair use or trademark fair use or right of publicity fair use that have all taken away this impression from Campbell that only parodic use cases, cases in which you are directly commenting on or other criticizing the original, can be fair. And I would say that the U.S. government test that was pressed by the Solicitor General's office is a same variation on this misunderstanding of Campbell to limit fair use to just parodic use cases.
And real quick, the poll results so far.
Okay.
Okay. We have 56% Warhol Foundation, 44% Goldsmith. Pretty close.
Pretty close.
Interesting.
It's a blowout in an election.
Right.
All right, now the government.
Mr. Chief Justice, and may it please the court. 2 questions drive factor 1. Does the use serve a distinct purpose or instead supersede the original? And what is the justification for copying? Both point against fair use here.
Counsel, in what way is the government's position different from that of respondents?
We accuse respondent that the most straightforward way to establish fair use under the first factor is if your use is commenting on the original, criticizing it, or otherwise shedding light on the original. But fair use is an affirmative defense, and we would leave open to defendants in various cases to establish that their copying was justified for other reasons.
So I would just note, and maybe in here, that there's a clear distinction that's been drawn in some court cases as well as in the general literature about the difference between parody and satire, right? So satire, Campbell noted, needs more justification for the borrowing. The Supreme Court never said in Campbell that satire was de facto not a fair use or presumptively unfair to establish the Sony Betamax commercial presumption on a new issue. And so I think in this case, a lot of what pop art does, for example, is take pretty unremarkable images and make some commentary about them. And the whole point of taking those images is their very unremarkableness, I guess. And so it's these images, according to pop artists, postmodern appropriation artists, these are images that are part of our cultural consciousness that we sort of see and have become ingrained in the advertising detritus of everyday life. And what makes them appropriable is the fact that they're pretty unremarkable. And so to even say that there's something to parody there, I think misses the point because of this idea that they're not being taken to poke fun because there's some unique object to poke fun at. The whole point you're taking it is because it's perfectly interchangeable, and that very interchangeability or interchangeableness or whatever you want to call it is being weaponized now against the Warhol Foundation by both the Solicitor General's office as well as Goldsmith.
So several of the justices seem to be a little befuddled, like many of the people who were listening to the argument live, about what the standard was that the government was actually proposing. And in fact, Justice Kavanaugh tried very hard to pin the Assistant Solicitor General down. Can we listen to that?
So the exact words we use on that question in the opinion, if we were to agree with your side, will undoubtedly be the subject of a lot of debate. So I want to get it exactly right. So what are you advocating? I've heard you say necessary, essential, or highly useful. Is that the formulation?
We would say that's a great formulation, or you could say necessary or at least useful, or you could say just essential, and I think that covers it. But I think the best way to explain it.
Those are going to be, those are very different in some fields. So what's your best, your best answers to what the best formulation is from the perspective of the United States for the opinion?
If you're going for the straightforward clarity of a one-word answer, I would say essential. The reason we use...
No, you can use multiple words. What's the formulation?
The reason we said necessary or at least useful, and the reason we used that formulation was because in a lot of cases, and a lot of the most straightforward fair cases, it will be necessary. And I think that's why respondent has used that word. We think that there are cases in which it is essential or highly useful, and those should also count.
I always thought necessary and essential were synonyms. If you say necessary and you say essential, that to me means the same thing, which is something different from useful or even highly useful.
We think that highly useful works too. And like I said, I think the reason that a highly useful test would work is in the book review context that I gave you on earlier, which it's not necessary, and I think in there are a lot of examples that's the case. I think using the word necessary does lead to more straightforward results in my run of cases.
Okay, I'm going to really pin you down again on that. Necessary or highly useful, or necessary or at least useful?
We would say necessary or at least useful, and the important thing is that it's an affirmative defense.
So that was Justice Kagan who was interjecting along the way as well. As I said, there were several justices who seemed confused. Now, I don't want you to think that there was no fun and games during this argument. In fact, that there's great mirth at the Supreme Court, as you probably are well aware. And we wanted to play just one clip where Justice Thomas got involved.
Here we go, ready? I have the music in the background.
I assume that the Orange Prince is copyright.
Yes, and I think that copyright's directly at issue in this case.
Let's say that I'm both a Prince fan, which I was in the 80s, and
No longer.
son, only on Thursday night. But let's say that I'm also a Syracuse fan, and I decide to make one of those big blow-up posters of Orange Prince and change the colors a little bit around the edges and put Go Orange underneath. Would you sue me?
I think my colleague Justice Thomas needs a lawyer. And I'm going to provide it.
This is a fun-loving bunch on the Supreme Court. So, David, before we all riff on where we think it's going, and I think you've already sort of given us a sense of how difficult it is to really prognosticate. I mean, there were a number of amicus briefs filed, many, in fact, and several of them, when I read through them, including one that I helped write for the documentary film community, suggested that if this case goes badly or if the court messes up, that it's going to destroy entire creative industries. What do you think the impact of this decision is going to be on fair use and creative industries generally?
Okay, well, given the existence of 4 plenary Supreme Court rulings on fair use, one would naively assume, okay, this field is straightforward. But as we've seen, it is anything but. It's very hard for me to imagine that a 5th decision will engender magic lines that everyone can follow. It seems to me that things are bound to remain indeterminate even after this 5th ruling. I would love to comment on the difference between a necessary justification and an at least useful justification, but we can get to that more.
Well, no, let's go for that, because I think that really gets us to the nub of where this might be going, and it'll probably lead to our second poll.
Okay, well, those two are the opposite. If the Supreme Court were to issue a one-sentence decision, we hold that fair use arises when the justification for copying is that it is necessary. I think a few defendants would still prevail in fair use, but 99% would lose. Here's an example of one that would prevail. The Fourth Circuit ruled that the following non-productive use is still fair use. When a service called Turnitin gathers high school papers and puts them all on a server to detect plagiarism, those are all 100% non-productive copies, but the only way that they can do their purpose, it's necessary to copy the actual student papers. They can't have hypothetical student papers to do that. So that would be a rare case that would survive. On the other hand, if the one-line ruling from the United States Supreme Court is when the justification for copying is that it is at least useful, then it is fair use. If that were the standard, then I think every defendant would win, even the most paradigmatically unfair cases. For instance, there was a case in which the Sixth Circuit remarked that, Pirates with Attitude said the reason we're copying the copyrighted works is because we have a site that everyone can access this and it's fair use. So the Sixth Circuit said that doesn't even pass the straight face test. But it is useful. It's useful to people. So if that's the standard, that would be fair use. Everything would be fair use.
In fact, I was imagining as I listened to the government articulate that, all of my documentary film clients saying, of course it's useful, that's why I'm using it. Mark, what do you think about the government's position, and how likely is it that the court is going to adopt the test that the government is proposing?
Yeah. So I think the idea that the Supreme Court's going to be able to announce a single rule that will then capture how we think about fair use is a fool's errand. And I think actually the thing that scares me most is that they will try to do that, right? I think one of the things, maybe just as background to think about, so one reason why this case is, for me, somewhat unpredictable is that the two justices over the past several decades who were the most knowledgeable about and interested in copyright are both gone from the court, right? Breyer and Ginsburg. So we have a bunch of people who are kind of new entrants into this field. We don't really have a clear sense of what they think about a lot of stuff, but what scares me about it is that there's a mismatch, I think, between the general methodology of this Supreme Court, which tends towards textualism and sort of rigidity about rules, and what fair use is, which is an equitable doctrine, right? And so, my 1Ls will not be surprised to hear me say, fair use is a common law area. Courts should just decide cases. They should not try to make grand pronouncements because there is no generalizable principle that they should be trying to say it's only fair use when it does. And so I think the tests that that the government is offering, or the necessity tests, are perfectly good examples of that, right? If we had a test that says, once we know the stated purpose of the use, then we have to know that it's necessary for that purpose, then we're just going to litigate about the legitimacy of the stated purpose, right? We're just going to say, well, fine, it's necessary to that purpose, but you shouldn't be doing that purpose in the first place. That's an illegitimate version. So the framing is going to dominate. And then when we start thinking about necessity, who's going to decide if it's necessary? Well, obviously, the artist thought it was necessary. That's why they did it, right? And so now we're going to have a court in the position of deciding, yes, I know, artists, you've told us this was necessary, Andy Warhol, but we just say you're wrong about that, right? And that's runs to me straight into the head, the sort of general concept we've had for a long time coming from the Bleistein case, that courts aren't supposed to be engaged in sort of artistic judgment, but a necessity test seems to me only to be about artistic judgment, and so I don't know how else you would do it. So what scares me most about the case is that the court is going to try to it will take the bait from these people and think they have to announce a rule, when instead they should just decide the case.
Cian, you want to take a shot at guessing where you think this is going?
I think a couple of interesting things in addition to what you said, Mark. One is that, yes, the two of those who are most interested in copyright, Ginsburg and Breyer, are gone. Breyer, notably, actually has been, I think, against copyright expansionism. He's taken a pretty conservative view of the copyright monopoly. However, there are two active justices sitting on the court who have at least been interested in authoring opinions or dissents that haven't really gone over that well. Star Athletica, some of you may be familiar with cheerleading uniforms. The dissent in Oracle v. Google, arguing that Google's copying of Oracle's API was not fair use, was authored by Justice Alito. They're textualists, and I did sort of see a resurgence of textualism in the oral arguments, especially when we talk about Factor 1 and commercial use. Commerciality is right there in the statutory text of Factor 1. It's subsequently been sort of questioned as whether or not it's, at least the Sony presumption is established in the Betamax case, that any any commercial copying is presumptively unfair, going off the legislative text. That's been, done away with by Campbell subsequently. And so there is a question of, is that going to come back? There was a very textualist brief that was submitted by Jane Ginsburg, who is at Columbia and is Justice Ginsburg's daughter, and a couple of other law professors, who made that textualist argument that what we need to be focused on is the commercial nature of the use in Factor 1, kind of basically maybe bringing back the Sony presumption. Lisa Blatt, counsel for Warhol Foundation, kind of honed in on that brief in her appeal to the court, and you could even see Justice Jackson, I think, really interested in the commercial nature of Warhol's use.
So I was just going to say two things. First of all, Two Live Crew's song was a commercially distributed song, right? So if we have a presumption that commercially distributed things, then we're just going to say any art that is sold is presumptively non-fair use. That seems to me a totally unsustainable position over time. Also, I'd just say Star Athletica seems to me exactly the right case to point to as just an absolute disaster that is a consequence of an attempt to do wooden textualism on an area that where it doesn't belong.
Okay, I have to subscribe to that last comment. I totally agree with it. See, and I want to agree with you that there was textualism in the Manel, Balganesh, Ginsburg brief insofar as it made a point about the word transform. But usually, textualism is antithetical to legislative history, and that brief mines very deeply in the legislative history. So I would imagine that that brief that Lisa Blatt recommended to the court will not be cited at all by the Thomas Alito faction of the court because it gets into legislative history. But it makes a very important point, which is the following. The word transformative, which was beatified by Campbell, is not a word that occurs in the statute. To the contrary, the statute outside of fair use defines something, namely a derivative work, which is a work that is transformed. But a derivative work belongs to the copyright owner. If you write a best-selling novel, you possess the right to determine who makes a motion picture about it. So it's not fair use for the filmmaker to say, oh, I transformed it. I added new characters. I added a subplot. I cut out a bunch of stuff. It's transformative, and it's unfair. So the brief did a good job of showing that we cannot place all of our eggs in the basket of the word transform because it traduces the statutory scheme.
So we'd like to open it up to questions because I assume that most of you came here with ideas and questions of your own. You didn't just come for the lunch. So
There are mics in the front. If you can ask from your seat, and we'll see if we can hear you.
and I'll repeat the question. So just please speak up when you ask.
They paid to use that photo, the Warhol. So why not just rule that they got to pay again?
So the question is, the magazine publisher paid the first time the $400, so why not just rule that they have to pay again?
The answer at oral argument was, Mr. Martinez said, in Campbell, they asked for permission, they didn't get permission. So the fact that they paid once, which they didn't have to, does not detract from the fact that it's fair use today.
However, there's an important practice pointer here that I think we should all point out. My guess is that the lawyers at Condé Nast who were involved in the second magazine didn't know about what was done the first time. And so it's always worth trying to find out whether or not you can be consistent within your client's enterprise. Cal. Oh, okay. Okay.
Blue shirt. Yeah, there we go.
Okay.
Thanks. My name is Courtney Rajaman. Thank you for the Institute for Technology Law and Policy. Do you want me to go to the mic?
Either way.
Either way.
So this can have really big impact, obviously, beyond this particular case. So I'm thinking about what are the potential implications, for example, intimate image sites. Rate My Professor, where you take images. We're seeing copyright is increasingly used by victims of harassment or intimate imagery as a way to try to gain back some control over that. But these sites are essentially derivative or transformative. Say you put a filter over the digital image, you transformed it. So what might the implications of the decision of this case be for pursuing copyright as a remedy for the posting of intimate imagery or other types of problematic aggregation of this sort of information online, opportunities to harassment?
I guess I'll say that maybe this is actually a nice example of what I was saying before, that if we were to go down the road of deciding that the way we think about whether something is fair use is to say the artist gets to propose what their purpose is, and then we decide whether it's necessary to advance that purpose. So then those sites just say, well, like our purpose is to circulate unwanted images, right? And so then obviously we need the images to do that, right? That's our purpose. And this is what I was saying before, which is now we're just going to have an argument about whether that's a legitimate purpose in the first place, right? So it just seems to me it's like turtles all the way down, right? If you say, well, I have to decide whether this is necessary to the purpose, but we're just going to allow whoever the proponent of this is to freely decide what the purpose is with no constraints on that. I can't even imagine that's going to be true, right?
I have a question on this.
Okay.
What does turtles all the way down mean?
It means that like you propose like a word or a test as if that's going to resolve the case, and then all you do is just like move over to the next space, and you've decided, well, now we've got to figure that one out, and then you just have like a, perpetual string of those, like as if you're ever going to get to the answer.
Cal.
First of all, this is a great panel, so I'm glad we're doing it. David, your point about derivative works was interesting, and I guess I wondered about how all of you thought about the case law in terms of different art forms. So it seems like we ordinarily think of derivative works in the context that you gave. There's a book, and then there's a movie, or something like that. We rarely talk about it in terms of art, fine art. And so it does seem like that's a huge window for eliminating a lot of what's acceptable, or has been acceptable by the courts in the art world, going back to Prince v. Carrier and cases like that. So how do you distinguish the different art forms and the way that they map on to this kind of messy matrix of cases?
Yeah, can I? So I think it's interesting because I think the concession that Latham made right at the outset of oral argument was that, of course, you need a license to create a movie out of a book. Side note, I'm friends with Latham and counsel for Warhol, so we were texting about this after, and we kind of like after. And his Mr. Martinez's partner and I agreed that concession should not have been made. I think that the industry does a lot of things. We talk about this in my entertainment law class as risk management, right? So you're basically buying a license as an insurance policy because you don't want to encumber your film with a ton of lawsuits and bad publicity. So it's not that when you take out a license to make a film out of a book, you're necessarily agreeing that it can't ever be fair use. You're just saying you don't really feel like dealing with a giant copyright lawsuit and arguing fair use in the back end. There's been a lot of great scholarship written about how fair use in particular is really susceptible to industry practice, and courts allow industry custom and what's done in the private sphere shape how they determine what is fair and what is not fair, and I think that's a great example. I think what's interesting in the art world is that the custom until now in the art world has been not to get a license. For whatever reason, artists are just, they just create their work and they don't think about the legal ramifications. 99% of it falls under the radar because they're never gonna get famous, and then 1% becomes Andy Warhol. And so it's an interesting question about whether or not this is going to change the custom, I think, in one of the only remaining copyright industries that actually don't license as a norm.
And as someone who comes from the journalism side and the documentary film side, this is a constant tension for documentary filmmakers who come from newspapers or television and say, we never license these things, we don't get releases, but the insurance companies insist upon it, and the platforms insist upon you getting insurance. So it has become customary that you license the close calls, and only if you can get a law firm or a documentary film legal clinic to write an opinion letter that says this is a fair use, do they actually go ahead and fair use. If the decision goes the wrong way, though, that will change the documentary and probably the news reporting businesses very dramatically.
Let me talk here so that hopefully, yeah, okay. So I want to pick your collective brain on and ask you to go back to that to the clips that you played, the exchanges between Blatt, Kagan, and Kavanaugh about the highly useful, necessary, essential. So the question is, so I was a little surprised about that because it seems to me that the very definition of parody, so I'm talking about fair use just through parodic uses, okay? The very definition of parody is like you engage in, you rework something to make a point that is very specific to that work, right? So the Roy Orbison, the Two Live Crew. So it's not that you start by saying, okay, I want to write a song that criticizes traditional gender politics. So which piece of music should I use? Maybe I should use Orbison. That's not how it works. You start with the work. And it's a sui generis reworking of a cultural artifact that you want to do to convey a certain meaning. So you don't start with my project is X, the best tool for the job is Y, and that's why I'm using it. You start with it. So it seems like something becomes, whatever you want to call it, necessary, essential, extremely useful, after you have made the decision that you are going to work with that. Instead, if you're thinking satire, I can see that in the case of satire, instead, you can say, okay, I want to make fun of X, okay, and I'm not going to go and engage X directly. I'm trying to make fun of the OJ trial, and I'm going to use it. I'm going to use the cat in the hat. So in the case, you have a choice of what you are going to mobilize for your purpose. So in the case of satire, I can see that argument. But in the case of parody, it looks like everything becomes necessary after you have decided what to do.
Yes. No, but I think it just puts more pressure on the point that then everything is framing, right? Everything is the decision about what was your project in the first place, right? And then I think after Campbell, because Campbell makes this distinction between parody and satire, not as strongly as many courts interpreted it to be later, we had this thread of cases for a long time that's saying, oh, parody, that's fair use, but satire is not so much fair use. But, Andy Warhol's not parody, right? And so this is, I think, the folly of trying to, have a rule that's globalized, you can globalize to everything, right? It's like to Cal's question before. I mean, one of the many reasons why trying to state a general rule of fair use is that the fine art world is really different than the journalism world, is really different than the documentary film world. And maybe the rules are not the same in those places. And we should just be okay with that.
Right, and I agree. And so the government's test is not a one-size-fits-all test, as you point out. It would not be very good for the parody case. It might work for this case, although in fact it failed this case as well.
Alex?
I'm Alex Sullivan. I teach internet law and privacy law here. It seems to me that if the court looks at this as an artistic case, that it's going to go for Goldsmith because the entire work was taken, and I don't think there is a parody argument that's very strong for Warhol. And I think, as Mark said, if they're just deciding this case, I think it goes for Goldsmith. But if they care about the economics and the economic impact, it goes the other way. And as someone who worked on the Sony case when I was a very baby lawyer, I can tell you, if we had won that case, we represented the studios, it would have completely changed the way home video and the video streaming industry evolved, because then it would have been a copyright violation to copy the entire work. I think in this case, it has, as Dale has been suggesting, very big economic impact if you can't take the entire work and transform it. So I'm wondering if you think this is a case about art or a case about economics.
I'd like to embroider on your point because the panelists have been entertaining the counterfactual. What if we lived in the bizarro universe and the Supreme Court had decided each and every one of those cases the opposite way? So you had won the Sony Betamax case and then okay, et cetera, et cetera. We have learned to live with the rules of the 4 Supreme Court cases as they exist. It is my contention that in the bizarro universe, people would have adjusted. There would not be even in that universe an extremely straightforward argument that forestalls debate in fair use cases, which is why I predict that this case will likewise result in probably a like degree of indeterminacy as we have seen before.
In fact, I think we've seen something along those lines from the Google Oracle case, where the court made some pretty big pronouncements about the public benefit versus private benefits, and there was lots of money involved. And the plaintiff's copyright bar, the protective side for original creators, have simply tried to cage that decision as it's just a software case. It doesn't apply anywhere else.
I mean, so obviously, the world adapts to different cases, but of course markets look different afterward, depending on, that it depends on whether you think you're neutral as to various forms of organization, right? There's a reason why they litigate these cases in the Supreme Court, because it matters to their economic interests, right, into those, to that degree. So, I mean, I think it, also, the ability to adapt around a case or to cage it off depends on the bigness of the pronouncement, right? Like the smaller the case is, the easier it is to distinguish it from lots of other circumstances. And I think, your discussion about sort of art versus, economics. So, David mentioned earlier that sort of like transformativeness had become kind of the 800-pound gorilla. But of course, part of what was going on was actually people starting to use the word transformativeness in lots of different ways, right? And to say we can think about transformativeness in the way the Second Circuit did, which is like we can just look at the two things side by side and think in the four corners of the works, does this look different than that? Which sounds a lot more like substantial similarity than it does like transformativeness. Or you can say, is it a transformative purpose, right? Which is Google Books, right? It's just basically, it's a complete reproduction of the works, but for a different economic purpose or a different sort of social purpose. Or we can ask, was there a different, did the artist have a different meaning or message, right? And so transformatives itself started to become many things, right? And I think that was a recognition of the fact that the cases were different from each other.
I can see a world in which they can create a lot of indeterminacy by, I think, doing what at least two of the justices, Kagan and Jackson, had been telegraphing they wanted to do, which was they said, oh, so before us is just factor one, but factor four is not before us. But there could be harm to Goldsmith's licensing market, can there not? They're like, oh, well, that factor wasn't briefed, right? So they can just say, okay, well, we find the Second Circuit erred on factor one, and we're going to remand for a reconsideration of the remaining factors, including how this use potentially harmed Goldsmith's licensing market. That's pretty, I mean, that's a win for Warhol in the sense that they reversed the Second Circuit, but that's pretty damning on factor four, if they even include a statement like that, or at least say, you know, you have to reconsider this because we know what the Second Circuit found on factor four. It wasn't favorable to Warhol. And so then say the parties settle. Then you have, right, you have like a ruling that's maybe marginally in favor, but really creates, I think, a lot of unknowns.
Right. One last question. Gentleman in the yellow shirt.
Sorry if this brings it way too far back to the basics, but I'm still struggling to quite understand why the necessity or usefulness is necessarily a great tool to evaluate the purpose or character.
Did you hear us say that we thought it was a great tool?
No, but it seems to be what a lot of these cases strike upon. They decide that the purpose and character as a whole is parity, and I'm not sure that those should even be combined. Maybe they should be split and evaluated separately. And then they go to a necessary or usefulness tool, especially in the case of parity. And I'm not sure why that occurred, or normatively why we think that that's effective or good or useful for the sake of.
David?
Yeah, it is not necessary and it's not even useful.
Mark?
Yeah, I mean, I think I've made my views about the necessity rule sufficiently clear, but I think I'll just say it's, you know, if you think of these cases in true common law style, it is one thing to say, in this case, it strengthens the argument for fair use that it was necessary to the purpose. That's different than saying, in order for it to be fair use ever, under any circumstances, it must be necessary, right? Those are two different statements.
All right, so one last poll.
Okay.
Anybody change their mind?
Wait, and while I have your attention, as you take a picture of this QR code, we need everybody's help to clean up. So we're going to be passing out Lysol wipes up and down each hall. Try to grab one, wipe the tables. There's a class after. You don't want fish sauce when you're in class. And then throw your trash out outside instead of in the classrooms. Don't leave yet. We got to do the poll. I was just saying that so you would hear to clean up. All right, so poll. And then Zach will tell us the results while I pass the mic to Dale.
So I'd just like to say thank you to our excellent panel. There's a lot to talk about here. I'd encourage you to read the transcript of the argument. And I want to reemphasize something that was said before. The only way to really understand this space is to read the cases. I say this to my classes all the time, but it's the only way that's ever going to make any sense to you.
And we have poll results.
Okay.
And we have poll results. The poll results switched, and they are now heavily in the Warhol camp. 65% Warhol, 35% Goldsmith. Is it all because you want to take Dale's classes? Okay. Thank you, thank you, thank you.